and welcome to How to Make Your Own Will Online. All right, so I'm going to teach you guys how to go online and create your own will. So, one of the most difficult parts of this is going to be the fact that we have 50 states in the United States. And if you're watching this outside of the United States, I have no idea what you should be doing. You should probably find someone in your own country who's made a video like this. But if you're in the United States, each state has its own rules on how to create a will. So I'll try to give you some tips on how to handle that. I'm a Texas attorney, so I'm going to be using Texas forms and stuff like that. So we're going to go online here, and we're going to, if I was put into the position of, oh, I need to create my own will, what do I need to do? First thing I'm going to go do is, maybe I'm about to die or something like that. And so it's going to be like quick here. So I got to figure out something, what's going on. So I'm going to type in Texas will templates. As you can see, I already looked this up, trying to get ready for this video to make it nice and easy. And you're going to see all these like e-forms, Form Swift. All right, if you want to, you can use these forms. You're going to pay for them. Free downloads is never free. That's a key word. Whenever they say free downloads, it's not going to be free. They're going to make you pay for that one time. All right, you have these organizations like this one for Austin Police Retirement. Okay, that's probably not the best thing. You got wills and testaments. You can go through here. I had to dig down deep in here, and I had to go and look at a bunch of stuff. And I eventually found this form that I've kind of already come onto and made a little custom for so we could get into this. But we're going to focus on this, and we're going to go through and create our own will. So at the very top of the document, oh, wait, I forgot a step. We got to go back one step. So the other thing you want to Google is Texas or your state, whatever it may be. Don't look up my state when you live in a different state. All right, that's a key point I want you to be aware of. Okay, so Texas formalities. Oh my gosh, I forgot how to spell formalities there for a second. Well, I think Google helped me. Thank you, Google. Oh, shoot. That's embarrassing. All right. So right here, once again, this is just another person's law firm that's putting this out. I want to look for the Texas State Code. So every state has its own code. All right. So I want you to find your own code. Here it is. And this gives me all the rules on how to create a will. Every state has their own code and says, okay, what are the rules? So we have in here who can create one. Oh, well, you have to be at least 18 years or older. Okay, so we have some rules in here about what if you're going to disinherit, writing and testing that if it's in writing that it needs to have some witnesses in here. Okay, we have to have 2 of them or more credible. They have to be at least 14 years of age. So I got to remember all that kind of stuff. So this will help and guide you. All you have to do, look, it's not that long. Okay, and most of this is just like, well, how do you do the self-proving affidavit and stuff like that? You just read through this and make sure you hit all these points. Okay, as long as you hit all these points, you're going to be good. But the template, hopefully you should not assume that who created your template knew what they were doing. Never assume that. Because anybody can create a template, upload it to the internet, and you're just using that template, and it really doesn't do anything for you. I can't tell you how many times that I've run into problems that people have done online wills, and there's some formality that was forgot and not put in the document. So make sure you take the time to read through and make sure your will actually is going to meet that. But most states, almost every state, a few states have like 3 witnesses, but most states have the same requirements as Texas. And this will, we're going to hit them all. So first off, I'm in here. I'm going to create my own will. And since I've already come in here and I've made it nice and easy for me. Usually templates will have some kind of bracket system like this. You go in here, you go replace, okay? You put, and right there it says name. Well, I'm going to put my name. I love to put names in all caps in wills. The reason why is so easy to find names because names are the most important thing. A will really is supposed to accomplish 2 major things. Number 1, where is your property supposed to go? And number 2, who is in charge? Those are the 2 things that I want to know as an attorney when I'm doing your will. Now you can add other things. We're gonna add a guardianship provision for my minor children because I have 5 kids, and I want to make someone's life really miserable when I die, and so I gotta figure out who I really dislike, and I'll put them in as my guardian. But we're going to put in here. So first off, if you know the replace all function, that's great. It makes it nice and simple for you. So I'm going to replace all, and it's going to replace everywhere where that bracket for name is. Now, when you're going to do your own will, if you're a cheap ass bastard and you will not pay an attorney to do this for you, then you need to take the time to actually read and go through it. First off, read the first sentence here. I, Taylor Willingham of Collin County, Texas, make this my last will and testament, and I revoke all wills and codicils previously made by me. It's very important that last phrase is in there. If your template that you have does not revoke all previous wills, please type that in. You need to revoke anything that you created before. Because if you have a will that maybe you created with a girlfriend, you got too drunk, and you didn't realize that it's still out there, it might cause you problems later on down the road, okay? Because if this will is not valid, you might not want that will probated. Because most of the time you're creating will, you're like, well, I don't want my property to go to that person. So make sure that you put that statement that you're revoking all prior wills. All right, I'm married, so I'm going to come in here and I'm going to put my wife's name. Once again, do the replace all function. You go in here, copy. So it's going to insert her every place that it's going to say wife's name. So my wife. All right. She is the lucky Miss Willinghammer. So we're going to replace all that. All right. Oh, gosh. In this, it says I have 2 children. Oh, whoops, I haven't done that yet. I have 5 because I'm crazy. So 5 children. And yes, I know how they are made. So I don't need that question ever asked to me again, please. Please don't. That joke is not funny when you have 5 kids. You know, people have 5 kids have been asked that question like 1,000 times, so it's not funny. So we're going to come in here, and I got to remember every one of their names. Dallin Willingham. I got to put his last name in there. Now, a lot of people go, oh, do we need to put their middle names in? No, this is identification. Notice the title of this, article identification. Unless you have kids with the same name, then you need to put their middle name in. You don't need to put their middle name in if they all have separate names. And so if you're not George Foreman, then you don't need to worry about this. Okay? So, Kai's my second one. What's my third? Oh, yeah. Tayson. All right. Willingham. Kind of like Taysom, you know, that plays for the Saints. He's awesome. Then Mela is my next one. Takes me a minute to remember. And I have Jax. All right. There is my kids. I have to list all the children. Now, if you're a man like me, you are confident you know all your children. So you got to put them all in there. If you fail to put a kid in there, that could cause litigation purposes later on because then you didn't know they existed, and we don't know if you would want to leave anything to a kid. If you're a woman, you don't need to worry about this because you know all your kids. Women know all their kids. Men are confident they know all their kids. So at this point, it then is going to give you some kind of identification here of who are going to be considered my kids. I specifically exclude, you notice down here is excluding any any children born after I have passed away. So in other words, you can't take my genetic material and create a kid and have them included in this list. I don't want that to happen, okay? Only, you know, my kids when I'm alive. Article 3 here, this is kind of just this doesn't need to be in a will, but I like to put one in. A memorandum, what that is, if you ever see that language in your template, most states don't allow this, and even Texas won't honor this, but I always put it in. This allows me, if I want to make a handwritten document and leave my household personal effects to whoever I want to. So things in my home, like if I wanted to leave my gun to someone, I could write it on a piece of paper and leave it with a will. If you're going to do this, you need to do it in your handwriting or you need to type it up and sign it. Now, in Texas, a lot of states will recognize this. In Texas, we do not legally recognize this if someone challenged it. However, to date, I do about 100 probates a year. I've yet to have anyone ever challenge a memorandum because no one cares about your junk. They just want your money. So no one ever fights over this, but I'm sure it's happened before because there's actually case law on this. I want to be cremated. Now, one important thing in here, if you want to, you can put who you want in charge. That way, the funeral home, if there is a fight over what's done with your body after you pass away, you can show the will, and it's a notarized document so they can accept it and know who has, and I said my executor. I want my executor to cremate me, and they can decide what they want to do. All right? The next article, and this is very important when you're creating your own wills, understanding this concept. This concept is difficult. A lot of people don't get this. Specific gifts, things that you mention in your will, come out first, okay? So if you say, I want my house to go to this person, I want a car to go to this person, I want this item to go to this person. If you list out that in this section, in the specific gifts, I'm saying, I'm just saying, hey, I don't care about my stuff. Just give everything to my wife. That's what it says in here. And then if not, just follow the residue distribution below, which we'll get to. But specific gifts come first. So a lot of people don't understand. They go, oh, okay, well, I want to leave everything equally. But I want my one son to have the house. Well, guess what? That means they're going to take the house and give it to the one son, and then everything else is distributed equally. Understand the difference of those two concepts. Specific gifts come first. So if you say, I want to leave $100,000 to this one child, and then everything else is divided equally among my other children, and you only have $90,000 when you die, your first kid gets the 90 grand. They get everything. The other kids will get nothing. So this is the problem with specific gifts, especially cash gifts. Is usually when you pass away, you spend all your money. It's usually what happens. That means you did it right. The problem is if you don't spend your money, then that means you did it wrong. So we want to make sure that specific gifts are not going to interfere with the residue gift, which is whatever's left over. Now, in this one, if you read down here, you come down here, if my wife survives, I want to give everything to her. I want her to have everything. That's usually what people want. And, unless things are not working out very well, then, you might not want that. But in my case, I do. And then I want everything to go to my descendants. Now, I usually do a per capita at each generation distribution. Most people do what's called a per stirpes distribution. You can go online and read the difference between the different distributions, but I'm going to give you a per capita. Basically, per capita is the concept that I want to treat at a generation everybody equally, okay? So if all my children are alive, it will divide 5 ways among my children. If one of my children has passed away, their share will pass to their kids. If multiple kids of mine have passed away, the grandchildren are all going to be treated the same in their generation. Okay? Now that's confusing. You'd have to go online and read a little bit more about it. But in my mind, I always like the per capita each generation distribution because I like equality. All my kids should be treated the same. All my grandkids should be treated the same. Okay? A per stirpes distribution does it differently. A per stirpes goes by family. So if you have 2 kids, they're going to go 50-50 between 2 kids. If one of your kids passes away, their share will pass to their kids equally. So let's say they had 5 children. So their 50% would divide 5 ways. In a per stirpes distribution, if your other kid passed away but only had one kid would get 50%. The other 5 would divide 50%. That's why I don't like a per stirpes distribution, because it doesn't treat people equally at the end. And when I've done probates where this has happened, I have found out that this is probably what the testator, the person who created the will. And if I ever say a word that you're like, what the heck did he just say? There's a thing called Google. You just Google what it means. Testator means creator of the will. So if someone creates a will, they usually want everybody treated equally at a certain generation. So just want you guys to remember that. Now in this, I say, well, if all 5 of my kids pass away, we all, apocalypse happens. I call this apocalypse scenario. I'll take half of it, give it to my wife's family, give the other half to my family. I don't care. It's like, why should I care? I'll be dead, right? I wrote a whole book on that. So in here, I've already inserted, so when I did a replace all, I had my wife's name, so it replaced my wife. So Usually you want the person, if you're giving everything to your spouse, you want them to be the executor of the estate unless they don't have the capacity to do it. The reason why is because they'll get it done. So I am appointing my wife to be an independent executor. You see that phrase? That's really a Texas thing. That just means that you can act independently of court oversight. You're also going to see like personal representative. Every state calls this position differently. There are different functions. Like you could ask someone to be a dependent executor. That would mean that they would have to do what the court says, and then you have the court have to oversee. No one really does that, but you could if you wanted to. But understand that phrase, independent executor or personal representative, that's based upon your state, what they call it. But if you used executor or personal representative, in Texas, we know what a personal representative is. Okay, if my wife fails to pick me, I'm going to then go with my father, okay? So I'll put my dad in here. All right. Notice how I'm going line by line. I'm not getting like lazy here and going, okay, I'm not going to read what this line says, okay? So I want my dad to do it. My dad can't do it, okay? Because you notice how this is all flowing. So you put somebody, then you need a backup because you could die with your spouse. So my dad, he's older than me. This is one of the things you need to think about as executor. So you're sitting down trying to pick your executors. You're going to pick somebody older than you. They're most likely going to pass before you. That's just logical. So you need to make sure you put a third person in, okay? And in this situation, I have a good friend that's an estate planning attorney. He knows what he's doing. I would pick him to do it. Charles Malolo. All right. And he would be the one that would be able to do everything. I know he can handle this. He can put it all together. I know he's an honest person. So I've picked him. He's my age, though, so it kind of worries me. You know, I know I'll redo my will. If you don't think you're ever going to redo your will again, you probably might want to put a generation younger, your kids, somebody their generation as the next alternative. In Texas, we have a requirement to post a bond. I'm always putting in here, I don't want you to post a bond, okay? The next is, my executor is not going to get paid. Charlie might not like that, and he might refuse to do it. But I don't want my executors to get paid. I want them to do it out of the kindness of their heart because it always causes problems when people get paid. Now, if you only have one kid and you're appointing only your like you have a spouse and have one kid, I would always pay the executor in that scenario. The reason why is, what if you die with a whole bunch of debt? Well, your kid could probate the estate and get paid as the executor, and he gets paid before the creditors get paid. So it's a way to get an inheritance, okay? All right, we have ancillary executors, multiple executors. These are just, terms like I wouldn't, if the template put this in, I'd just leave it in here because it's probably helpful for some reason. Guardianship provision. Okay, this is my favorite. Who do I dislike the most in this world to make the guardian of my children? Because that's fine. That's going to be a miserable job. So I got to think who I want to torture here. No, I'm just kidding. I'll be kind to my kids. So in this situation, I'm going to go, you know what? I have someone that can handle 5 kids. My sister-in-law, we're going to put Lisa Cordova. Okay, and I need to change this right in front. A lot of times you want to identify how are they related to you. Because if you put a very common name in there, how's a judge supposed to know who you mean? So I want to say sister-in-law. All right. Notice up here it says first, hey, you can't override your spouse's right to your kids. So you can't be like, oh, if I die, I don't want my wife to do it. I want, this person to do it. No, it has to go in order. So first my sister-in-law, Lisa would do it. And then if Lisa couldn't do it, who would I pick? Oh, my kids would really be in trouble then. Who would take 5 children? Who do I want to make? Oh, we'll do my mother-in-law. Now this is dangerous because she's older. And I'm picking someone older than, so I'd probably, if I was doing this correctly, I'd put another person after this. Cindy Budge. I would probably put another one, someone around my age to raise my kids. So if I was doing this right, but for time purposes, we're not. And I'm getting a call from a spammer. Thank you. Thank you for wasting my life. All right. Now, executor powers. Okay. So in here, this is an important section, and most people don't understand this when they write their own will. Just because you appoint an executor doesn't give them full authority to do everything. Okay? It usually means if you wrote a will and just said, this is me, this is what I want, this is where I want my property to go, and this is my executor, and then you ended it. That means you want a judge to oversee the whole process. In other words, that executor needs to go back to the court every single time they want to do it, sell a house, sell property, because you don't fully trust them. In here, in the state of Texas, we can give the executor powers. In other words, I'm telling a judge through this section, I'm giving all these powers. I'm giving the power to retain property, to sell and exchange it, to borrow money from any source that they need, to make it, and distribute any property under this will as needed to the guardian executor. I'm giving them full power to do everything. Invest property, enter into any transactions. These usually, if you just type in executor power, your state, state code, Illinois executor powers, they're probably going to have a list that you can just copy and paste in here. Okay? This literally is copy and pasted from the code. All right. You will get at the end of most templates, you're going to get to a miscellaneous section. In other words, these are the sections that there's been a lawsuit or there's some kind of benefit that's given if you add these in. Well, a spendthrift provision. Basically, this is telling my executor they're not to pay the creditors of my beneficiary. Okay, I want to be clarified. My debts have to be paid upon my passing. I'm telling my executor not to pay my children's debts. Okay, the money goes to my kids and they can pay their own debts. So if they had like a student loan or something like that and they defaulted on that student loan, the spendthrift provision right here is saying, give it to my child. Now, they may have a judgment against them. They may have to deal with that. But my child will then have to pay because I want them to do any kind of asset protection that they can do. They can do. Now, if you do a trust, there's a way to do an asset protection trust so you can withhold that from their creditors for the rest of their life. That's a benefit of a trust. Survivorship provision. All this is saying right here is that someone has to live 30 days after me to inherit. The next, what is a descendant? It's probably pretty important to identify what descendants are because it's kind of confusing in today's age. In my definition here, it's saying, okay, it's children born after I die. They're not included unless my wife was pregnant at the time that I was going to pass, but she better not be because I can't have any more kids. The second is going to say the spouses of my children are not included as descendants. So if my son passes away, my oldest Dallin, before me, his wife doesn't inherit. Okay? And it also says in here in my definition that step-grandchildren or stepchildren are not included as my descendants. So if my child marries someone that had a child from a previous relationship, they are not my descendants unless I come and add them. That's how I usually design. That's how I would design it, but that's what this descendants paragraph is saying. Discretion. All right, that's just a discretion clause. I'm putting it in the discretion of my executor to make the distribution. Genetic material, what that means. Incapacitated. I don't want my executor to be handling my money if they're incapacitated. Make logical sense, but I need to define what that means because people differ on what that means. I've been in court where people have said, my sister's an idiot. She's incapacitated. She can't be the executor. I should be it. Well, in here I defined, or this is defining, this template defined it. I'm not doing it, but technically I'm doing it because I'm using the template. I'm saying there's 3 ways to be deemed incompetent. One is a court finds that you are, a guardianship's placed or a conservatorship is placed over the executor, or 2 physicians say. So if that were to happen, then that would hit. I define what heirs means. Okay, heirs are what the state of Texas determines what an heir. Every state has a different definition of what an heir is. So make sure you're saying, oh, well, I understand what that means. Because eventually, after my children, if my children have no kids, if all 7 of us pass away, I'm leaving my property half to my heirs, half to my wife heirs. So I need to know what that means. Per capita each generation, I define it here what it means. And no contest clause says basically when you put a no contest, you're saying if you challenge the will, this will, you're going to lose your inheritance. So notice I didn't go in and edit any of the end stuff. Usually it's a good practice not to do that because you don't know why it's in there. It's usually in there for a reason. So if you want it in there, you can. Now, one thing I don't like a big empty space on my page 8 there. So what I'm going to end up doing here, this is going to look a little weird, but I'm going to move this up. Okay? So I need to go one more. Okay? Either I'm going to move up or move down to kind of fill in that space, but I'm going to do this, and I'm going to move it up. I know it won't be completely formatted all the best way, but that's good. Now, in the state of Texas, we allow you to do this. Most states don't allow you to do this. You can sign, witness, and do the self-proving affidavit all on the same page. Before 2015 in the state of Texas, we didn't allow this. You couldn't do this. Now we do. Other states still do not allow this. So that's something you need to know. Most states require you to sign and witness on one page. And then they'll have another separate document called the self-proving affidavit. What that document is when you pass away, a will has to go through probate. It has to go to a court. And when it goes to court, we can't just take the will itself as evidence. We need the witnesses to show up at court and testify. In Texas, we only need one. But someone needs to come tell the judge, yeah, that was my signature. I did sign that. Also in Texas, you don't have to have someone go to court. You can have someone fill out an affidavit. And there's no requirement when they fill out the affidavit. So way back in the day, a really smart attorney just said, well, you know what I'm going to do? I'm just going to have them fill out the affidavit at the signing. So I don't have to go find these witnesses 20 years from now. Because a lot of times the witnesses die first. And that's a big problem to have. So in this situation, you're doing the self-proving affidavit. The self-proving affidavit is right here where it says the undersigned blank and blank. So that would be the 2 witnesses. Each being at least 14 years of age after duly sworn, declare that the testator and to the undersigned authority that the testator declare to us that this instrument is the testator's will, blah, 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 blah. Okay? That is saying what they witnessed at the time of the signing. This document is incredibly important. It's usually a separate document. It's at the back. They call it the self-proving affidavit, but that's what needs to be notarized. In Texas, if we went back to the formalities, you don't need a will to be notarized. It just needs to be witnessed by 2 witnesses. But the reason why we have a notary here is the self-proving affidavit has to be notarized. Okay? And so we're going to have our witnesses sign. Now, let's talk a little bit. The mistake that's made all the time is the signing. We call it a signing ceremony because everybody has to come together. You get everybody into the room. Oh, there's one last thing I want to make sure. So down here, I initial every page. It's not required in the state of Texas that you initial every page or sign every page, but make sure your initials are there. Okay, we're going to make sure that's done right. But in that case, I'm going to initial every one of my pages because I don't want someone to slip page something in. Okay, and in this case, we're going to have a signing ceremony. At that ceremony, this self-proving affidavit, just read it. Just read it off. Because that is the statement, and you look at both the witnesses saying, do you guys agree? Yeah, we agree. This person is competent. They can do what they want to do. You're going to sign both and put their names in here and sign both in here, and then you are good to go, and then this will be your last will. So that is how you create your own will from a template. Okay, so if you're sitting down and you want to do this from a template, you can do this yourself. You follow most rules. You got to take some time to research some things. Don't just jump in and go, oh, I can do this. Read the formalities of your state, what they require. You don't know if the state requires 3 witnesses or just 2 or whatever else is going to go on. So I need you to take the time out to research this yourself. Or you can go online and find an online company that has already created the template, and they just have you fill out everything. You still have to execute it yourself. They usually charge around $90 to do that, to use their forms. Or most attorneys, for about $100 more, will draft a will for you. So you can pay $100. Why would you use an attorney? Well, if you have some money, you're going to use an attorney because he's going to ensure that it's done right. Because if he does it wrong, he can get sued. If you do it yourself, you get no insurance. You just got to take it yourself that you did it right. So when I'm doing my wills with people, I go through it with them. I make sure it's done right. We usually have 2 meetings and we go through the whole thing. But as you can see, you can do a lot of things. Now notice there were some things that were not in this trust that you could do. You could put a trust in a will. We didn't do that. This is not a pour over will, meaning pouring everything over into a living trust. We didn't have a lot of provisions in here of, well, what if this happens? What if that happens? What if I die, my wife dies, and my kids are all minors? How are we going to take care of it? So it gets a lot more complicated. But very simple will like this that you could do. Yeah, you can pull it off yourself. That's how you do it. Just take the time, go through it, and put it together.